Please be seated. Good afternoon, Council.
Good afternoon, Judge.
All right, in case some of you folks don't know me, I introduced myself at the last hearing, but in any event, my name is Judge John Sanders. I'm one of Kansas's senior judges, and whenever there's a situation that perhaps require an out-of-county judge or whatever the situation may be, one of us gets called to help out, and so that's why I'm here. I'm from El Dorado, retired, but still do this part-time senior judge thing. So that's why you have me today, and for the case. All right, I think we're probably ready to proceed, and the matter that is before the court at this point is civil case 13C30, the state of Kansas versus Jeffrey Curry, Sheriff of Franklin County, Kansas. It is a petition for ouster. Counsel, would you announce your appearances, please?
May it please the court, State appears by Todd Hyde.
All right.
May it please the court, Jeffrey Curry appears in person and with his attorney Trey Patton.
All right, thank you, counsel. All right, what we had set for hearing today was a motion that the state had filed for temporary suspension. And counsel, are we ready to proceed with the case today?
Following negotiations, we are going to withdraw our application for suspension once Mr. Curry makes a statement on the record about his intentions to resign from office.
I see. Okay. Counsel?
Thank you, Judge. After a great deal of deliberation, my client is announcing that he has decided to voluntarily resign his position effective April 1 of this year.
All right, Sheriff, you've heard what the attorneys have announced. Is that indeed your intention?
Yes, it is, Your Honor.
Okay. And how are you going to do that? Are you sending a letter of some kind in? I'm not sure on that. Does that go to the governor's office?
Yes, Your Honor.
All right. And I would assume that you are at this point preparing that and are ready, or will be ready soon to go ahead and send that in to the governor?
Judge, we've already prepared it. I've given Mr. Hyatt a copy of that letter. It will be going out immediately.
Okay. All right. All right. Very good. Go ahead and sit down. Let me think about that a moment. That being the case, as I understand it, then the state is now withdrawing the motion to suspend the sheriff pending his resignation, and I believe that will still leave the ouster proceeding on the books, at least for now. If he does go ahead and resign, what is the state going to do about that?
Your Honor,
I assume it would render it moot.
that's exactly our position as well, Your Honor. At this point, the application for suspension would be moot based upon the sheriff being on a voluntary administrative leave. As soon as his resignation becomes effective at 5 o'clock on April 1st, the petition for ouster becomes moot, and our intention is to dismiss that case on April 2nd.
All right. And I think perhaps you just answered one of my questions, and that was, as I understand it, the sheriff will be on administrative leave from his duties until the 1st, until
That's correct, Your Honor.
Okay. And is that correct, Sheriff?
Yes, Your Honor.
All right. Tell me a little bit, coming in on these things from out of county and not knowing exactly what all is going on in cases. Have you already just physically vacated your office there and are on, or put you, I don't know that, since you're an elected official.
Judge, if I could address that, I can
Okay,
bring the court up to speed. Pursuant to an informal agreement with Mr. Hyatt's office, my client has not been administering his duties since the inception of this action. That was an agreement
I see.
where we had to do that as a part of the agreement. My client has given this a great deal of thought and consideration and has decided that rather than to proceed with the civil action, he's going to voluntarily resign his position. We still, of course, have the other case, which involves identical facts.
Okay, all right. Well, that answers my concern about, because probably under the circumstances, keeping in mind that everybody's innocent until proven guilty, I was of the opinion that the best thing to do would have some kind of administrative leave situation until this matter is resolved or until the resignation becomes effective. And if that's what's happened, well, then I think that's certainly appropriate and would approve that. And request that remain the case until the resignation becomes effective. And just a quick follow-up on that, I assume that is the deputy sheriff, has he assumed the administrative details of the sheriff's office?
Your Honor, we've left that up to the county counselor to determine the transfer of power. So I understand the undersheriff is acting in that capacity right now.
I meant the undersheriff. All right.
That'll be up to the county counselor, and I think that's why we have the delay in between today's hearing and resignation to allow for the orderly transfer of power.
I see. Okay, very good. All right, well then, the court will go ahead and grant the state's motion to dismiss or to withdraw its motion for temporary suspension. And just for the record, that will leave the case still on file for Ouster until such time as it might be dismissed or other actions taken in regard to that case. Okay. And counsel, if you'd prepare an appropriate order on that, I'd appreciate it. Now, let's talk about a few other things that we have here and how we might take care of them. For Mr. Hyatt, perhaps this question is just for you, and that's in regard to the other criminal case against the other officer, Mr. Fredericks, or Officer Fredericks, which is one felony count there of interference with law enforcement. What's the status on that? That is a felony case. It was my recollection that we were going to, perhaps, at least for purposes of hearings on criminal matters, combine the two cases together for presentation of evidence, but I don't recall for sure about that. What's your thought on that?
Your Honor, we provided discovery in both criminal cases to counsel. They've had about a week, I guess, to review that. It's our position that those cases should remain consolidated for preliminary hearing. It's substantially the same evidence. It's all identical witnesses. It's going to be the same evidence for the court on both cases. So simply for judicial economy, that makes sense. haven't received an objection from either counsel for either defendant. In absent that objection, I can prepare an order for the court consolidating these two cases for prelim.
Okay, well, I think that would probably be a good idea to go ahead and do that also.
Judge.
I've forgotten, or perhaps I don't know, who is representing Officer Fredericks?
So, Mr. Chris Brown?
Chris Brown?
Yes, sir.
I think maybe you told me that.
Judge,
hang on just a second. Does somebody have their phone buzzing?
I think it's the door.
The door? Okay, all right.
Metal detector.
You want these doors closed?
No, that's all right, no problem. Everybody check right now, make sure that your phone's not on. I do that and then mine rings. All right, so, yeah, I'm sorry, it's
Chris Brown, Your Honor.
Chris Brown, okay.
Judge, we won't have any objection to consolidation for purposes of the preliminary hearing, but we will want to reserve the right to object, potentially for the purpose of trial.
Sure, I understand, okay. Now, April 1st at 1:30, I believe at our last hearing, we reserved 2 hours that afternoon, and I believe that was for a preliminary hearing on those cases. Is that correct?
It is, Your Honor. 2 hours seems kind of tight.
Well, it may be, and probably that day I'm pretty flexible, so if you wanted to do something in the morning, start earlier, or change the time on it, well, we could certainly do that.
I've got no preference either. With 2 defense attorneys, if that's the way that this ends up playing out, we might need 4 or 5 hours. I anticipate 8 to 9 witnesses.
All right. Yeah, just let me double check first. Well, I have nothing else, so assuming that date works with everybody, if you want to start at an earlier time.
The morning is difficult for me. I could potentially start at 11 o'clock a.m. if the court wanted to. But you know, my guess is that 2 hours is going to be very difficult. It may actually be closer to 3 or 4 hours.
Well, I would imagine so. Well, we could do one of 2 things. We could go ahead and see how far we could get that afternoon, and then, if need be, finish it up at the next day or something like that. Or now, just looking at my calendar, April 2nd is totally free if you want to just slip the preliminary hearing on both cases to April the 2nd, which is a Tuesday at some particular time, assuming that we would hopefully have a court room.
Judge, April 2 is impossible for me. I have other hearings in multiple jurisdictions that are evidentiary in nature.
Your Honor, if it would be acceptable with you, when I'm preparing the order for consolidation, I can conference in Mr. Petlon and Mr. Brown. We can try to come up with a suitable time for everybody. If you're open all day on the 1st, I'll talk to them about starting earlier and how long they think it will take.
Okay, we can do that. As far as I can tell, give me just a second. One nice thing about being partially retired is your calendar isn't too terribly full. I've got the 2nd, 3rd, 4th, or 5th, that whole week right now, with the exception of this second of the afternoon of the 1st. I've got it free, so, but I don't want get going on. So if we could do that, surely first, second, or third maybe might be able to work with you.
The second does not work, the first is a good day, and then maybe what we can do is check with Mr. Brown's schedule and either start the hearing earlier on the first, or figure out if he's available also on the third.
Okay, all right. We'll leave it that way. If necessary, I would extend the defendant's bonds to whatever day we pick, if it's a day other than the first. You gentlemen talk, first, second, or third is fine with me, whatever time, whatever day. And if somebody then could just let me know, and be sure and let our clerk know also, and maybe you ought to ask her about the second and third. It looks like these days will work for the court, so we'll leave that open, and counsel let me know on that, okay?
Yes, sir.
All right. Okay, now, there's a couple other matters I want to take up, because we do have motions that have been filed by the media in regard to the sealed records. And is counsel for either Channel 5 or for the Ottawa Herald here?
We are, I'm Allison Ouster for KCTV 5 and the Kansas City Star.
Michael Merriam, Mr. Pico for the Ottawa Herald, Your Honor.
Okay, good. You're both here. I'm glad you are. Let me see. If I recall correctly, I have already authorized Channel 5 to intervene, and you have you actually filed your motion to unseal yet? Was that attached to your request to intervene?
It was, Your Honor. We filed, you granted motion to intervene last Friday, and then the motion to unseal was deemed filed as of that date this month.
All right.
And just for clarification, I represent the Star as well.
Okay. All right. And let's see, Mr. Merriman, I believe you filed your motion to intervene and attached a copy of your request to unseal with it, or was that your memo?
We didn't file a motion to unseal yet, Your Honor, but we did brief the issue.
Okay.
And on the motion to intervene, it's my understanding that the state and the defense do not object to the Ottawa Herald's intervention. The question of whether matters will be unsealed, I think, remains for Your Honor's decision.
Right, right, okay. Well, I think that, I agree that is the status. And I take it that neither the defense nor the prosecution or the defense in the Ouster proceeding, that there's no objection to the media intervening. Would that be a correct statement?
That is a correct statement.
Yes, Your Honor.
All right, okay. All right, well, that being the case, the court would go ahead and grant the Ottawa Herald's motion to intervene and to file a brief in the case in regard to unsealing.
Thank you, Your Honor.
You're welcome. Now, I imagine the state may have a position in regard to that it wishes to take, and to file some kind of a response brief or a brief also in that regard, and perhaps the defense too. I don't know. Gentlemen, did you give them that any thought? Please sit down if you want to, counsel.
We'll follow a response, Your Honor, mostly laying out the balancing test for the court and the factors that we think are important. But we can have that on file shortly.
Okay. counsel, where are you on that, or do you know where Mr. Brown is on that question?
I don't know where Mr. Brown is on that question, Judge. I would like to file a response myself, and if the court wants to set a deadline for that, that would be great. We can submit pleadings and then potentially schedule a hearing.
Okay, because I know that issue is something that, regardless of what else happens in our cases, is something that the court's going to have to deal with and make a ruling on. It is an important issue, and I know that it's necessary to resolve that one way or another. Let's see. Counsel, could you have, well, I guess the Herald probably wants to file every, of course, I assume everybody's going to be working with the same case law and theories and all of that. You all just want to, I don't know if you want the Ottawa Herald to file its brief and then respond to it, or just file your own.
I think ideally that's the way we would do it, so I can see precisely what the Ottawa Herald is alleging.
Okay.
And then maybe it'll be similar to the brief that's already been filed, but ideally we would have something to respond to.
I would imagine it probably would be. Mr. Merriman?
Have you heard, Your Honor?
Sure.
We won't be saying anything new in a new brief. We've already briefed the issue of unsealing. We just hadn't filed a motion to do so.
Okay.
So when I do file that motion, I'm just going to incorporate the brief we've already filed.
Okay. And counsel, you've gotten that, is that correct?
Yes, Judge.
Okay. Okay. Let's assume that Mr. Merriman has filed it or would shortly. How long would counsel like to have to respond to these briefs? Week?
I was going to suggest maybe 10 days. So I have an opportunity to, obviously got another press of business scheduled Monday through Friday, so maybe April 1.
We may be meeting here that day anyway, so if you want to say, on or before April 1, 2013, to file any response briefs to the motion to unseal.
Yes, Judge, thank you.
And counsel, well, I think the clerk, and counsel, I think you have my email. Would you send a courtesy copy to me? You could just PDF it or something like that, or a Word copy, either one would be fine, so that I'd have a few moments anyway to take a look at that.
Yes, sir.
Okay, all right, very good. With the filing date for any responses being April 1, we still might need to set a date for oral argument on that. Counsel, whatever, what are you thinking in that regard? Or do you want, as far as I'm concerned, if you want, I'll decide on the briefs, but anybody that wants to have an oral argument on this, that's certainly fine with me.
Assuming we keep the preliminary hearings on April 1, I'd like to have the arguments done April 1 as well. It's my intention to dismiss the case on 2nd is moot. I need to keep it open just for that purpose, but I
Well, that's true.
will do so.
That's true. So, maybe as far as when, council, you get to talking about what day you want to select for the prelims, you might incorporate media's attorneys, make sure they're available if they want to make oral arguments. Council, what are you thinking about back there?
Yeah, Your Honor, I would just request that, that we get the briefs, before, if we're going to hear and argue this on April 1, I would like to have the brief, at least a day in advance and not get it as I'm walking into the courtroom, probably a couple days in advance.
Okay. Well, why don't we just leave it then that the briefs are due April 1, and then when we're here to take up the preliminary hearings, we'll perhaps set a date at that time.
Oh, I'm sorry, excuse me, Judge, and to be clear, I'm comfortable with arguing it on April 1.
Just as long as you got it a little bit ahead of time.
Yeah, because mine's
Okay.
been on file for quite some time. And technically, I think it's a 7-day response date, so the response is technically due tomorrow. And so if we, push it out to April 1, that's quite an extension on a matter that's fairly timely.
Okay. Well, counsel, I don't know if you've got is your brief ready to go this morning?
Yes, Your Honor.
Okay. Well, get it on file as quickly as you can. And due to the nature of this, I'll say no later than April 1. I'll give an extension to that. But out of courtesy to the attorneys back there, as soon as you get it on, I'd appreciate it so they'll have an opportunity to take a look at it. And then we'll just play it a little bit by ear on the 1st or whatever day we take up the prelim. And if everybody's ready to go on some more arguments on that, we'll do it then. And if we need a little bit more time, we'll take it. Okay? All right. Let's see. I believe you said that the deputy is on administrative leave or some, I read it in the paper. Okay. So everybody's on administrative leave. Anything else that we need to take up at this point?
Nothing by the state, Your Honor.
No, Your Honor.
Okay. All right, very good. Council, I'll see you April 1 or April the 2nd. Just let me know for sure what you've all agreed to as far as the preliminary hearing date, either one of those 3 days. And we'll proceed at that time with those matters and anything else that comes before the court.
Thank you, Judge.
Thank you.
You're welcome. Thank you. We'll be adjourned.
right, take it easy.
Drop the gloves, is that?
Yeah, I kind of dropped everything, yeah.
Well, I guess we'll